Good afternoon, everyone. We are thrilled you have joined us today. Thank you so much for joining this webinar brought to you by the Lawyers Committee for Civil Rights Under Law. My name is Katie Euchre. I'm the director of the Economic Justice Project here at the Lawyers Committee. We're going to get started with our program in just a minute, but first just wanted to give some folks a few more minutes to log on. In the meantime, for those of you who are on Zoom, just a reminder that you can enable closed captioning by selecting the show captions under the more options button at the bottom of your screen. And finally, if you want to get some updates about Lawyers Committee's work, please visit our website at lawyerscommittee.org. Thanks for joining us today. We'll get started in just a minute. Hello, everyone. Good afternoon, and thank you again for joining us today. We're going to go ahead and get started with our program. So on behalf of the Lawyers Committee, thank you so much for joining us to learn more about the Supreme Court's affirmative action cases and what the decisions could mean for the workplace. We're going to hear from some experts and get some more information about what this could mean. And we have an excellent lineup of speakers who are very seasoned employment lawyers and experts to help guide us through what this decision, the potential impacts of this decision. So many employers have long used race-neutral policies and initiatives to advance diversity and inclusion in their workplaces. And after the murder of George Floyd, many employers stepped up to call out systemic racism, commit to racial justice, and implement DEIA initiatives. These are designed to increase access to employment opportunities for Black workers and other underrepresented workers from many different backgrounds and identities. And recently, we've seen a backlash to these efforts. The affirmative action cases are just a part of a broad and coordinated attack on racial progress and civil rights that we're seeing. But no matter the Supreme Court ruling that's coming down this month, it will not change our commitment to realizing a multiracial democracy. It's very important in this fight that we arm ourselves with accurate information. And so today, I'm so pleased that we have this panel to help arm ourselves. We're going to get some expert advice, some expert analysis and insight. So first, we're going to hear from David Hewitt, who will give us an overview of the cases before the Supreme Court. Then we'll hear about the state of the law now in terms of the use of race in employment. We'll talk about what the cases could mean for employer practices, including DEIA efforts. And we'll hear about effective DEI measures and the wide-ranging benefits these initiatives can have for businesses, workers, and the economy at large. Finally, we'll hear about the importance of continuing these efforts for our country. So without further ado, I would love to introduce you all to our president and executive director of the Lawyers Committee for Civil Rights Under Law, Damon Hewitt. Damon has more than 20 years of civil rights litigation and policy experience, including prior leadership roles in the nonprofit, philanthropic, and public sectors, and more than a decade as an attorney at the NAACP Legal Defense and Education Fund. Damon has a deep background in education law and is perfectly suited to guide us through these affirmative action cases. Thank you, Damon. I will now turn it over to you to give us a bit of an overview.
Thanks so much, Katie, and everyone, our virtual participants, for joining us today, as well as our expert panelists. We're thrilled to be joined today by EEOC Chair Charlotte Burrows, who is a veteran of civil rights litigation and analysis and policy. One of our very own board members, Adam Klein from out in Golden, a former co-chair of the Lawyers Committee, Executive Committee board. And also Michelle Crockett from Miller Canfield, a great partner in the Midwest based firm, and also Sheila Madali from the National Legal Advocacy Network. We're so pleased you could join us today. I want to talk a bit about background on the cases that the Supreme Court should be ruling on at some point soon, although we're waiting on whether new decision days will be announced, because we've all been on pins and needles. But before I do, I want to just say that it's so important that we ground, as Katie alluded to, all of the analysis that we provide to you and all of the analysis you provide to others, whether it be your clients, your partners, your family, and your friends, grounded based upon facts, not fiction, based upon facts, not fear, frankly. We know a lot is at stake, and we'll talk about that. We're not Pollyannish about it, but we want to make sure we're clear about what is at stake and what is not. So first, just some background on these cases. I have been, I'm not sure if it's a privilege or not, but I've enjoyed the ride of being part of litigation efforts in all of the affirmative action cases that hit higher ed in the last 20 years, starting my career around the time that Gratz and Grutter were going up the Michigan cases, and then of course playing a key role in coordination of amici, co-coordination of amici during the Fisher 1 case, Fisher v. UT Austin, and that work has continued to now with the work the Lawyers Committee has done in the UNC Chapel Hill case and also the Harvard case. So on October 31st of last year, the Supreme Court heard oral arguments. That was Halloween, but we believe that, we try to stay away from the tricks and focus on the treats on Halloween. But the cases were argued that day, and I think it was an epically long argument. It was probably over 4 hours, I believe, which is highly unusual, although maybe par for the course for this court. What's important to understand is that there are some challenges that are unique to both cases, some that are unique to Harvard, but there's some challenges in common to both cases, rather. In each of the cases, the group called Students for Fair Admissions challenges not only whether university policies comport with longstanding precedent from Bakke and Grutter, but also whether that precedent itself should be overturned. Essentially, the potential here is for what we call a Dobbs play, as in Dobbs versus Jackson Women's Health, overturning precedent altogether and creating new law out of whole cloth just to suit this court's ideological needs. That obviously is the biggest fear that everyone has. Now, the Supreme Court has established and confirmed repeatedly that race can be one of many factors, rather, in college admissions and higher education. It's a critical means to promote diversity and the educational and other benefits that flow therefrom. And again, in the last 20 years, we have seen saves in the courts. They tell us every time that we're going to lose. They said, well, you're going to lose both Gratz and Grutter, and you're definitely going to lose Fisher. And Fisher, too, you'll lose that one as well. And that hasn't been the case. There have been saves in the Supreme Court and in lower courts as well. But unfortunately, what we get really concerned about is sabotage on campus and maybe even sabotage in the workplace, where the fear factor kicks in, the paranoia even kicks in, and there are overreactions, knee-jerk reactions to what people think are coming, and we understand the sentiment. We want to today to give you real facts to quell those fears. Now, the opposition in this case, it is clear the opposition is not just about higher ed. The opposition, it's Ed Blum, who created this essentially fake organization, Students for Fair Admissions, and he is on, we have a recording of him saying he's going out to find Asian plaintiffs. His intent was to drive a wedge. He's the same person who brought us the attacks on the Voting Rights Act that led to Shelby County v. Holder. So we have no illusion that for him and for his people, the case is about more than higher education. It's about his rabid pursuit of a race-blind world, which we know is both impractical and certainly not legally required. Now, these challenges in the UNC and Harvard cases have created great turmoil in the higher education community, as you may imagine, or if you're in that community, as you understand. And the idea and the fear is that it could change everything about admissions and maybe everything about campus life and how campuses operate. And many of you may be concerned about how it may change how workplaces operate. Please remember this. The issue, or rather the controversy before the court, is about higher education admissions, college admissions, nothing else. There is nothing at stake about race neutral recruiting and other methods. There's nothing at stake that would fundamentally change employment law, certainly not right away. That's really important to remember as people digest the decisions once they come down. We know these cases are part of a broader attack. I mentioned voting rights. There's also attacks on AP studies curriculum and critical race theory efforts all around the country in K-12 schools. These are all connected in many ways. What they all have in common, though, is that they're not organic. They are highly orchestrated, and they always have been. Since the moment we had affirmative action in this country, there have been orchestrated attacks to take it down. And we have sustained those withering attacks all these years. No matter what the court decides, we're going to continue to push forward, both in higher education and, of course, beyond. That said, we know there's a lot at stake, once again, for students of color and for you and the employment world. And at the Lawyers Committee, we're committed to being partners with you to think this stuff through together. We want to be very clear that DEI or DEIA programs, we believe, will not be undermined, certainly not directly or immediately, by the court's decisions in the UNC and Harvard cases. According to the EEOC, Title VII permits diversity efforts designed to open up opportunities to everyone. So no matter the outcome of the UNC and Harvard decisions, that will not change. Certainly that statutory language and the intent of Congress and the regulations will certainly not change. We think our country benefits when people of all backgrounds can come together, to learn together, to work together. We know that we produce better learning, better experiences, and frankly, better results for our country and for the world. We've already seen what happens favorably when employers remove unfair barriers, seek out applicants from all races and ethnicities, and create workplace culture that fosters respect. People can get these jobs and they can also thrive in their jobs as well. The ruling in Supreme Court cases will not change employers' affirmative duty to create workplaces that are free from discrimination. Many of you are seeing analysis out there that suggests what you won't be able to do in the employment landscape once these cases come down. That analysis is premature, and in some cases, sadly, we think it's simply wrong because discrimination is outlawed today, and it's going to be outlawed after the cases come down as well. The only question is what constitutes discrimination in the eyes of the court. And again, the cases are all about higher education, college admissions, not the employment context. So if we want to, as we say at the Lawyers Committee, build the future we deserve, our commitment has to be not with mere compliance with legal principles. Now that's true even outside of these challenges in the affirmative action cases. If you and your advice and your clients or in your workplace or in your organizations or associations are focused on mere compliance, we're missing the mark. The reason why we have an EEOC, of course, is for compliance. The reason why we have Title VII is to set a baseline of the law. But if we are to reach the higher aspirations and the fullest potential of this amazingly diverse country, this nation, what we have to do is go beyond mere compliance and actually talk about culture. If we're going to build the future we deserve, as we talk about at the Lawyers Committee, we have to do so not by focusing only on what the law bans, but also about what the law makes possible. I hope as you listen to our experts today, you can lean into that sense of possibility and also hold back any premature knee-jerk reactions to a case that hasn't even been decided yet. So thank you so much. I look forward to hearing from our experts. Back to you, Katie.
Thank you so much, Damon, for those words. Now, we are so fortunate and pleased to have Chair Burrows join us today as our first speaker. Charlotte Burrows was designated by President Biden as chair of the U.S. Equal Employment Opportunity Commission on January 20th, 2021. She was initially nominated to serve as commissioner of the EEOC in 2014, and the U.S. Senate later unanimously confirmed her to a second term ending in 2023. Chair Burrows has long advocated for strong civil rights protections and robust cooperation between the commission, employers, and employees to advance equal opportunity in the workplace. We're so happy to have you, Chair Burrows, join us. Thank you. And I'm hoping that you can help sort of level set for us and talk about, give us an overview of the state of the law now with regard to employers' use of race and DEIA programs. And what the EEOC is doing in these terms. So if we could start off, I'd love to have you explain to us and remind us what are the purposes and goals of Title VII of the Civil Rights Act?
Sure. Well, thank you and good afternoon. Hello to everyone who's joining us. And it is such a pleasure, Katie, to be able to join this panel. So glad to be here with Damon and the Lawyers Committee. So thank you for including me in what's really a very important conversation. So the EEOC, or Equal Employment Opportunity Commission, as most of you know, and you've just heard, is the primary federal agency charged with enforcing Title VII. And of course, our mission is quite simple, which is to prevent and remedy discrimination in America's workplaces. So we really understand and want to emphasize that Congress's purpose in enacting Title VII was clear: to prohibit employment discrimination based on race, color, national origin, religion, and sex, including pregnancy, sexual orientation, and gender identity. And those remain at the heart. We don't have time to discuss all of Congress's goals in each of those, the protected bases, but I will note that the Supreme Court has described in detail, and really relevant to this conversation, for some time, that there are particular rules for voluntary affirmative action and for DEIA. The Supreme Court actually addressed this back in United States of America versus Weber. Congress's primary concern at that time, according to the court, at the time of the inaction rather, was really enacting a prohibition against race discrimination to address the plight of Black workers in the economy, which included opening opportunities for Black workers in occupations that had been traditionally closed to them. And of course, that meant, in addition, inclusion for everyone. And that has been, since the inception, right at the heart of the core goals of the statute. Of course, it's been amended many times, but it remains a seminal piece of legislation that really has helped promote and expand equal employment opportunity for all Americans. And again, the goal is to have an inclusive workforce, and the statute really was deemed necessary to correct that. So that's sort of the touchstone, and I'm happy to talk a little bit more in detail about how that applies in this context.
Thank you so much. And if you could tell us what is DEIA? What do we mean by that? And how such programs fit under Title VII?
Sure. Well, as you know, DEIA in employment refers to diversity, equity, inclusion, and accessibility, policies or programs that seek to promote an inclusive workplace culture and reduce barriers to advancing equal opportunity for workers. So promoting DEIA, and this is what we found, but also what companies that have voluntarily decided to undertake these efforts are telling us, that it's important because it's really in everyone's interest for employers to hire qualified workers from all backgrounds and ensure that those employees, once hired, can fully contribute and participate with all of their talents once they're on the job. And so many companies have told us that DEIA efforts help companies attract top talent, spark innovation, improve employee satisfaction, and enable them to better serve diverse customers and communities. So that's what we're hearing from corporations, from a variety of organizations about the business case for DEIA. Many DEIA programs implemented by employers, such as recruitment efforts to expand applicant pools, are race and gender neutral, meaning that they don't involve race-based or gender-based employment decisions. And in some instances, employers may elect to implement what's referred to as a voluntary affirmative action program to increase the representation of specific underserved groups in the workforce. So the Supreme Court has long held that Title VII permits the use of certain voluntary affirmative action programs if they are properly constructed in the private employment context, or for that matter, in other contexts. And so there's two decisions, United Steelworkers of America v. Weber, which I mentioned earlier, and Johnson versus Transportation Agency of Santa Clara County, that talk about, and these are Supreme Court cases talking about voluntary affirmative action programs that don't violate Title VII. And what they say is that these plans have to respond to a manifest imbalance in traditionally segregated job categories. If they don't unnecessarily trammel the interest of employees who may not be the main focus of the plan or create an absolute bar to these employees' advancements. And they're temporary, designed to attain, not maintain a balanced workforce. If there's already diversity, then that is a different scenario than a scenario where there is not. And so in other words, employers can lawfully work to correct past discrimination in the workforce or to counteract past practices that resulted in a significant underrepresentation of qualified workers in a particular industry or job category. And the facts and the business case, of course, should be at the heart of those considerations, and that initial analysis of what's needed is has to be the beginning place if a company is looking at that or any employment is looking at that.
Thank you so much, Chair Burrows, for that very useful explanation. And so as I understand, the Supreme Court has established a framework for analyzing what we call voluntary affirmative action under Title VII and when that can be permissible. And then DEIA programs, which typically don't use what we would understand as affirmative action or the, I guess, explicit use of race in decision-making. And so there is a distinction from what I understand. And so what has the EEOC done to promote DEIA measures or other similar voluntary actions? And what have you all learned from employers about sort of what works in that context?
Sure. Well, so focusing on the private sector, obviously the federal government encourages diversity as well in our workforce. But over the past few years, a number of employers and workers' organizations have really been, reaching out and seeking actionable strategies to ensure DEIA programs can promote meaningful progress, while also ensuring that there's compliance, of course, with the federal anti-discrimination laws. And that's why back in January 2022, the EEOC and our partners at the Department of Labor's Office of Federal Contract Compliance Programs, or OFCCP, launched HIRE, a hiring initiative to reimagine equity, to respond to these needs and redouble our efforts to promote those actionable solutions to ensure equal opportunity in recruitment and hiring when companies wanted to do that. The initiative explores how employers can create real robust, meaningful pathways to good jobs for workers from underserved communities and really for all workers. And so this initiative defines diversity very broadly to include a variety of bases, including race, color, religion, national origin, age, disability, veteran status, and sex. And by sex, I include in that pregnancy, sexual orientation, and gender identity. And the HIRE initiative has convened 4 virtual roundtables focusing on how to do that. So promoting racial equity, reimagining equity for workers with gaps in their employment histories, promoting skills-based hiring to make workplaces more inclusive, and the civil rights implications of the use actually of automated technology systems like artificial intelligence in the recruitment and hiring of workers, how that may impact diversity as well. So these roundtables really featured a variety of speakers representing employers, unions, labor groups, and civil rights organizations that focused on concrete efforts and successes that they had that we wanted to make sure others were aware of. So collectively, the participants really have identified a number of barriers that left really capable, qualified workers sitting on the sidelines in the past because of discrimination and because some intentional or sort of traditional hiring practices, whether intentional or not, I should say, favored those who had connections already to the workforce or had the same background as those who were currently at a particular employer. And to break that open sort of focuses tended to work. And so that was really the goal of most of the programs that we were hearing about. Let me give you an example. Many common recruitment and hiring practices, like hiring primarily through personal networks or conducting subjective evaluations of whether a candidate is the right fit for a particular workplace, can serve to replicate an organization's current workforce in a way that really creates unnecessary barriers for talented workers from underrepresented communities. And those workers may be perfectly capable of doing the job, but just not have the same inside contacts as applicants from other backgrounds. And so that's a problem for fairness, of course, but also for companies' bottom line. And so employers' DEIA efforts really were seeking to correct that problem by creating a really focused and structured approach to ensuring that an employer actively includes all workers. So of course, the higher events have also identified a number of promising practices to promote DEIA in the workplace. Though that includes embracing DEIA at all levels of the company, focusing on skills and abilities when hiring, rather than relying just on education and positions previously held, but really looking, what does this job require? And seeking the candidates who had those skills, providing opportunities to talented, qualified applicants who have gaps in their resumes or work histories. And that can affect the formerly incarcerated, but also older workers, caregivers, someone who may have stepped back from the workforce for child-giving reasons. It's clear that many employers are already working to redesign recruitments and hiring practices to increase diversity in their ranks and to make sure that they don't leave any talent on the table. So it's been a matter of good public policy, I think, but also from a business standpoint and from our perspective, what's important, I think, for me to make clear is that it really is something that if you do this carefully, can be done fully in compliance with Title VII and the other statutes that we enforce.
Thank you so much, Chair Burrows. Thank you for your commitment and for bringing your knowledge and for all of your and the agency's work in this space. We're so grateful and appreciative of you. And I am now going to, we hope to hear from you some more. We might hear from you some more as we go on, but I'm going to open up now our webinar to our other speakers. And I'm so pleased to introduce each of them. So first we have Michelle Crockett, who is the Chief Diversity Officer and Deputy Executive Officer at Miller Canfield, which is an international law firm headquartered in Detroit, Michigan. In addition to serving as a firm executive, she also leads Miller Canfield's DEI practice, assisting employers with assessment and DEI strategy, program implementation, and training. We're so happy to have Michelle. And I'm also so pleased to introduce Adam Klein, who's a worker side employment lawyer and managing partner at Outten & Golden LLP. His practice focuses on class actions and impact litigation relating to race, gender, and immigration-based discrimination. He has extensive experience litigating race and in particular restorative justice cases concerning the ways that the criminal justice system result in collateral consequences for workers in the workplace. So we're so pleased to have both of you. And finally, we have Sheila Medali, who's the Executive Director of the National Legal Advocacy Network, which is an organization that leverages legal strategies and resources in support of the low-wage worker movement. Sheila has been involved in the struggle for racial and economic justice for 2 decades, focusing on the intersection of the law and organizing. Now, prior to her work at NLAN, Sheila served as the Director of Law and Organizing at the Restaurant Opportunities Center United, ROC United. We're so pleased to have all 3 of you and your different backgrounds and perspectives on this very important and timely issue. So my first question I will ask of Michelle. And if you don't mind, Michelle, giving us your assessment of how the Harvard UNC decisions could impact what employers can and cannot do under existing law and in what ways? Thank you.
Yeah, so first of all, thank you so much for having me here today. I am really excited to be a part of this really, really important discussion. So I think the answer to that question is will it have an impact? Will the decision have an impact? The answer is yes and no, potentially. And that's because should the court determine that diversity is not a compelling state interest, and therefore race cannot be one of the factors that is considered when making decisions in college admissions, the tentacles or potential reach of that ruling could influence the way in which employers structure their DEI initiatives and programs going forward. And that's because I think, as Damon indicated at the very beginning in his opening remarks, we know that there is an orchestrated attack on the overall concept of diversity. So we're going to need to closely analyze the decision to determine how broadly or narrowly the opinion may be, which will in turn, again, potentially dictate how employers communicate and ultimately implement their diversity initiatives as we move forward. Now, that being said, under existing law, no matter what the decision may be, employers will not, and I'm going to repeat that, will not have to immediately terminate their DEI, their existing DEI programs. But what it does mean is that employers may have to closely evaluate their programs to ensure that they do not adversely impact non-minorities or males. And remember that what I just said is something that employers are already required to do under Title VII and other applicable federal and state laws, and that's to provide equal employment opportunities to everyone. So in other words, an employer's obligations in that regard will not change, no matter what the court's ruling may be.
Thanks so much, Michelle. Yeah, I mean, the Title VII already requires employers covered by Title VII not to discriminate. And it sounds like it's unlikely that these decisions will change that requirement, and that applies to any protected category of people. So I think it is important for employers and workers to remember that that will very likely remain the law after the Supreme Court makes its decisions. Are you seeing these decisions or other actions already having a chilling effect on employers that you consult?
Yeah, to some extent, yes. And I think that's because, again, in my opinion, there's just a lot of confusion over the important distinction between affirmative action and DEI. Affirmative action, as we all know, is a very emotionally charged term, right? That is commonly associated with things like quotas and preferential treatment. And even though that is not what affirmative action is actually all about, that misconception is being applied to the term diversity and by extension to DEI programs. So as a result, because the UNC and Harvard cases have been labeled as affirmative action cases, right, as it pertains to achieving diversity in the college and university arenas, employers are paying very close attention and really thinking about how that decision may impact their ability to implement and to even create new diversity initiatives. It also doesn't help that in the last few years, we've seen a number of reverse discrimination lawsuits filed alleging that certain corporate diversity initiatives have adversely affected males or others who are not members of underrepresented demographic groups. So, for example, last year in 2022, in a matter entitled Duvall versus Novant Health, a $10 million jury award was affirmed by a federal district court for a former white senior VP based on the finding that he was, quote, fired on account of his race and gender to protect diversity during the company's D&I program implementation, close quote. We also, have seen the filing of a shareholder lawsuit against companies like Starbucks. That a lawsuit was filed against them in 2022, alleging that their officers and board of directors had violated their fiduciary obligations in adopting DEI policies that allegedly discriminate on the basis of race by incentivizing officers to establish a more diverse workforce and supply chain. I think what's really interesting about the policy that's being challenged in that case is that the goals that are outlined in the policy are things that we commonly see in DEI programs. So for example, one of the goals is to achieve at least 30% representation of BIPOC individuals at all corporate levels and 40% representation in all retail and manufacturing roles by the year 2025. Another goal is to promote accountability at the executive level by incorporating DEI measurements into the company's executive compensation program. So that's really interesting because a lot of companies have similar goals baked into their DEI programs, and the statutes that the organization that lodged this lawsuit are alleging have been violated are there's a Section 1981 claim, there's a Title VII claim, and various purported violations of state law. I think I would be remiss if I also didn't mention the fact that, what's going on in Florida and other states, but Florida in particular, the challenges that are being launched against establishments like Disney and the push to abolish any and all teachings around systemic racism in public schools, including public colleges and universities. I mean, understandably, right, with all of that going on, are making employers just a little nervous, right? And quite frankly, confused.
Thank you so much. Yeah, it sounds like it would be wise for employers now, given this uptick in that we're seeing sort of across the board in this coordinated sort of organized campaign, if you will, to challenge racial progress, and DEI measures as part of that, that it would be wise for employers to take a close look at their policies and make sure that they comply with existing law. But again, this is already the law, right? It's not something that we're waiting on the Supreme Court to change or to not change. It's like this, the aspect of whether DEI programs comply with Title VII, it sounds like is likely to stay the same. I want to, before we talk more about sort of how, what employers can do, I wanted to go back to why we're here and why employers started taking a closer look at their practices that may be contributing to systemic discrimination and barriers for some workers. And so I wanted to turn to Sheila and ask if you could, in your experience representing low-paid workers, can you just give us an overview of some of the barriers that Black workers and other workers of color experience in terms of employment opportunities, especially in the sectors that you represent?
Yeah, absolutely. And thank you for having me. I hope everyone's having a great afternoon and appreciate being here, and the kind of focus and conversation also including low-wage workers. So, at NLAN, our work really focuses on workers across low-wage industries. It tends to revolve mostly around temporary workers, service industry workers, protein processing workers, warehouse workers, and gig workers. And so what we see is in these low wage industries that there is actually a disproportionate rate of people of color being employed in these industries. And so it's not necessarily an issue of diversity in the low wage sector, but it's the fact that these jobs that people of color tend to be concentrated in are jobs characterized by low wages, precarity, unsafe working conditions, lack of benefits. And we really see a very consistent lack of career pathways and opportunities for workers to have economic mobility. We see workers for years upon years being locked into low wage, high violation jobs. And so, kind of specifically with regards to temp workers, we often hear from Black temp workers that they will, in the workplace, spend hours and hours waiting in temp agencies to be assigned work, kind of just sitting and waiting and hoping for work, while they see non-Black workers come in and be assigned work, regularly throughout the course of their day and day in and day out, traveling, often taking multiple buses to just sit in the agency and wait for the hope of work. We hear from women temp workers that they're often not offered the same jobs that are offered to male temp workers. And so just the type of job that they're being offered and the amount of work available is greatly reduced. We've seen situations where the discrimination through temp staffing agencies and host companies is as blatant as the use of coded language between agency dispatchers and host companies, using language like heavies to refer to men, lights to refer to women, basketball players to refer to Black workers, soccer players to refer to Latinx workers. And so we, to kind of dig deeper into what we were hearing from workers, engaged in some match pair testing in Illinois, Texas, and Tennessee to uncover some of this race and gender discrimination, and found, extremely pervasive discrimination in screening, in assignments, in the type of work, and the frequency of work that workers are being assigned. And with regard to, service industry workers, we see, significant occupational segregation. I previously worked at the Restaurant Opportunity Centers, and there we studied occupational segregation through worker surveys, interviews, focus groups, and also match pair testing. And we found that workers of color were really disproportionately represented in back of the house positions, and a significant lack of diversity in management. And I think one of the things that stuck with me the most from that was that in focus groups, workers who had been in the industry for years would share that the occupational segregation and lack of diversity in management was so the norm that they stopped even considering applying for higher positions, for managerial positions, because they felt they didn't meet the image. Not that they didn't meet the qualifications. They would often train white workers who would be in those positions. They knew they met the qualifications, but felt that they did not meet the image of management because of the norm of occupational segregation in the industry. And so in other low-wage industries as well, we see the direct connection between a worker's position and their wages, their safety conditions, the predictability of their schedules, whether or not they have benefits. And we see this having a direct result on workers in low-wage industries being pushed increasingly into more precarious work through, gig work, independent contracting, app-based work, because the policies and practices that exist at many companies for low-wage workers make it virtually impossible for them to work. And so, what we really see is, a need to expand DEIA measures and to make sure that they apply not just to workers in the offices, but to workers on the front lines, in warehouses, in restaurants, and retail, so that these workers actually have pathways to advance and have career mobility and to sustain their families.
That's so helpful, Sheila. Thank you for that. And it sounds like there's both systemic and intentional discrimination happening that's impacting low wage workers, like both in terms of outside the workforce and is causing, is the reason why we have such disproportionate representation of people of color in the lowest paid sectors is because of sort of the barriers that are set up in these other workforces, right? That are sort of funneling people to other low paid jobs. And then even inside the low paid workforce, like you're saying, in restaurant jobs where we see much higher representation of Black workers and the lower paid jobs within a restaurant than say the managerial spots. So thank you so much for those examples. I wanted to ask Adam, in your experience as a litigator, as representing employees, and how have you used sort of what we would call DEIA practices or other similar practices to resolve violations in that you've uncovered as in lawsuits? Thank you.
Yeah, thank you. Thank you for the opportunity to speak today. And I think one of the more interesting pieces here is that the term DEIA or DEI or equity and inclusion are old concepts with new labels in a way, in the sense that the Civil Rights Act of 1964 originally intended to address systemic discrimination that related to facially neutral policies and practices, so, particularly around employment suitability screens for hiring selection that had and continued to disadvantage people of color. And in that context, if you look at, for example, the White House's recent executive order on DEIA, it defines some terms that sound very familiar and are not new. So, for example, in that context, the executive order defines the term equity being the consistent and systematic, fair, just, and impartial treatment of all individuals. Well, that's precisely the target or the notion that is first found from Title VII, from the Civil Rights Act of 1964 as it applied to the workplace. And again, further codified by the Civil Rights Act of 1991, and in particular, codifying the disparate impact analysis standards for Title VII under the federal standard, and of course, been incorporated in many states' laws and cities' laws as well, that require an equitable treatment of applicants and workers, not equal treatment, equitable treatment, as defined by the executive order, and I would say more precisely defined in the context of Title VII, involving fair application of policies and practices in a way that does not disadvantage people of color or groups that are historically underrepresented in the workplace. So, to my mind, the sort of assault on DEI or DEIA, particularly at the state level, is really quite troubling and problematic, because what they don't realize, what's not being talked about, is that all of that predates this more modern discussion, by decades, by many decades. And at the time, starting in the 60s in particular, we had different terms for the same concepts. And so it's disingenuous and I would say very alarming that all of a sudden, out of nowhere, out of thin air, you hear this, sort of backlash against civil rights enforcement based on nothing. Now, there's no substantive difference between the DEIA initiatives, particularly around hiring selection and workplace practices, that provide for unfair or inequitable or unjust different treatment based on race or immutable characteristic. It's the exact same problem, just using different labels. So, and then to address your more specific question, or to answer your question, we have had any number of cases where we've challenged some aspect of a hiring practice. So, as an example, and with Lawyers Committee as co-counsel, we prosecuted and then eventually settled a case against the federal government where we challenged the use of criminal history records as a screen for employment for enumerators working for the Census Bureau. And in that case, the Census Bureau would basically screen out or determine that applicants were ineligible for employment based on arrest records, not even convictions, but arrest records. And of course, as we all know, there's a sad and prolonged racial difference in the treatment of people of color in our criminal justice system that gets directly imported into hiring selection, and particularly with the federal government. and governments more generally, tend to be some of the worst offenders in this area. And so you have a facially neutral policy practice, the use of a criminal history screen that has a very severe race impact in that case. And as part of the settlement of that case, we basically had the government, federal government, Census Bureau, completely dismantle their entire hiring selection process around criminal history records. And as a consequence, we went from very severe adverse impact, something like 2.5 times more likely for Black applicants to be screened out than whites based on criminal records, to no impact. Dramatic difference in outcomes. And you may say, well, that sounds like a DEIA initiative. I think it is, but the fact is, in that context, the employer, the federal government, was engaging in a practice that was a violation of Title VII, but also just a bad idea, because they were screening out applicants who were clearly qualified for the position and yet were excluded. And also, in contrast to the Census Bureau's own stated goal of having census takers reflect the racial composition of the people that they're interacting with in the public. And so it actually served against the stated purpose of the Census Bureau in terms of their actual hiring criteria. So, and all of that was essentially unexamined by the employer. In other words, the Census Bureau, and in fact, it happens all the time, that employers have hiring suitability screens or employment practices that they think makes sense on some level, that I describe it as something that you could explain to somebody on the street corner at the bar, and they say, well, that seems okay. But you look at it and say, well, where did this come from? And did you look at impact? Did you understand the race impact of something like a criminal history screen or excluding people with DACA status? That's really problematic, and it persists. And so I really do think that that's an incredibly important problem that we have to continue to focus on. And just the premise here that the Supreme Court in these affirmative action education cases would speak to that issue is really troubling. I don't think it will. I don't think we're going to see sort of a collateral adjacent impact on Title VII, particularly if we're careful in describing how DEIA initiatives are not new, and in fact are the precise tools and issues that were originally targeted when the Civil Rights Act of 1964 was initially enacted.
Yeah, it sounds like DEIA measures, or whatever you want to call them, that these types of measures help employers comply with their Title VII duties. And I'm wondering if you could just say briefly sort of what is employers' duty to identify systemic discrimination, or sort of unintended, we sometimes say, a discrimination that result from their policies and practices.
So I can answer that if you like. Basically, the employers under Title VII that have Title VII coverage, and frankly, most states' laws that have an anti-discrimination statute, require employers to assess whether their policies and practices disadvantage protected groups, and in this context, concerning race. And if that's the case, the employer really has to have a good business justification for continuing to use policies and practices that disadvantage groups that are covered by these different statutes. And that's a very high standard. I can elaborate on it if you like, but in so many words, the employer really has to have a very good business reason that where it could not be, the same objective could not be achieved through alternative means that have less or no impact based on race or other immutable characteristic. It's a almost impossible standard for employers to satisfy as a practical matter, because there are very few things that can be justified that also have race or gender impact. What would it be exactly? I mean, it's actually hard to come up with even a hypothetical where you could justify a policy or practice that has significant racial or gender or age or immutable characteristic differences in outcomes that nonetheless is a good idea from a business perspective, much less defensible under Title VII. So it's a very powerful tool, because it really requires employers to examine carefully policies and practices that disadvantage groups protected by anti-discrimination statutes. And when they encounter it, generally they have to dismantle them.
So important, and thank you. Michelle, I wanted to ask you sort of about what steps employers can take now to help ensure that their DEIA and anti-racist policies are defensible in light of these challenges and the potential decisions from UNC in the UNC Harvard cases?
Yeah, so I will respond to that question by just repeating one of my favorite mantras, and that is there should be absolutely no light between an employer's DEI team and their legal counsel, because for better or worse, in light of the impending Supreme Court decisions and recent uptick in the filing of lawsuits around DEI initiatives, the DEI arena has become more legal. So with that in mind, we need to adjust accordingly. So first and foremost, I recommend that employers carefully review their existing DEI programs with their legal counsel to determine or identify any potential legal risks. So, for example, in the recruiting arena, in the recruiting context, we know that based on a recent Sixth Circuit decision, it is not illegal to set recruiting targets, provided those targets do not require the actual hiring of more diverse applicants, which means it's okay. I want employers to know that it's okay to have a target or set a target to ensure that your applicant pools are as diverse as possible, and even set a target that they consist of a certain percentage of women and minorities. So cast that wide net, continue to do that. That is allowed under the law for now. In other areas of employment, I would say work very closely with your legal counsel because challenges have and will likely continue to be raised. So consequently, we have to make sure that targets that we may set in other areas outside of the recruiting context do not inadvertently thwart the ability of non-minorities to move into leadership positions, for example, or inadvertently target them for termination or layoff to the benefit of minority populations. So in sum, it's really, you got to make sure that your DEI team and your legal team are like this. Very simpatico.
Thank you so much for that reminder. And so I wanted to now start with you, Michelle, but ask everyone, we can do sort of a round robin on this one. But if you could talk a bit about why it's important for employers now to continue supporting their commitments to address systemic discrimination and continue in these efforts like DEIA. And Michelle, I'll start with you if you don't mind.
Yeah. So I think it's so important because whether people want to acknowledge it or not, the ability of non-minorities and members of underrepresented groups to be successful in the workplace and other arenas, it's really been thwarted by systemic discriminatory policies that have been in effect and enforced in this country for hundreds of years. Now, that does not mean that we have to persecute or punish people who have not been adversely affected by these policies. It's not at all what I'm saying or suggesting, but what it does mean is that we have work to do to ensure that everyone has a chance to simply get up to bat and compete for opportunities within the workplace, in the educational arena as well. And without these kinds of DEI programs that have been in place, I mean, for a number of years, I just think, obviously they're under increased scrutiny. Those opportunities have been few and far between for members of underrepresented groups. So it is imperative, if we really are committed to diversity, to promoting equal opportunity, as it was envisioned when Title VII was passed back in the 60s. We've got to make sure that we are committed to maintaining these programs.
And I will turn now to Sheila and ask sort of what these kinds of measures can mean to in terms of the low-paid sectors and for low-paid workers.
Yeah, absolutely. And I'll follow Michelle's lead and respond first with a quote, just from Dr. Cornel West, that just race matters. And since this nation's inception, race has been used to exclude, marginalize, and oppress people of color, particularly Black people in America. And that DEIA really is part of this larger struggle for racial justice and respect and dignity, really. And it's about how we respect people in this country and create environments where people can build confidence and thrive, where workers in low-wage industries feel confident in asserting their rights, their needs, their aspirations. For low-wage workers, particularly who are disproportionately concentrated in low-wage industries, DEIA would really mean an opportunity to have respect, equity in the workplace. It would mean skill building, pathways for promotion, diversity initiatives in management, structural changes in the workplace that really make it feasible to live and work and be able to support your families. We've seen, I think DEIA measures have really great impacts in a lot of industries, but the reality is a lot of these impacts have not trickled down to low-wage workers, and that we see workers of color really stuck in unacceptable working conditions and without opportunities for upward mobility or career advancement, and that we cannot really separate DEIA from workplace standards. Because people in low-wage industries, workers of color in low-wage industries, gender-oppressed workers in low-wage industries need and deserve wages, working conditions, and benefits so that they can provide and support their families and live just healthy lives.
Yeah, absolutely. I couldn't agree with that more, that, DEIA policies and practices, should include an examination of these standards and how they impact people, not just in the offices, but also in the warehouses and in the front lines, and the ways that that employer policies and practices are impacting those workers, especially. And Adam, I'm wondering could you give us some words about, in your experience, how DEIA measures and similar kinds of measures benefit companies and workers?
Sure, and I agree with everything everyone has said. I guess it's not a surprise. I will take a sort of a slightly different tact in just thinking about the issue from my perspective. So I've had the experience of suing major employers, Fortune 50 companies, and lots of companies in the financial services industry. And what becomes evident is oftentimes companies have existing DEIA programs and initiatives and offices, but however, there isn't a particular focus on the analytics. So when you talk about fairness in application and how systems are actually applied, there needs to be accountability through metrics, through analyses, through processes that are based on scientific method, the use of data analytics, for example, and some people call it criteria-related validity, just to be more technical about it. And there's just a body of academic work around these topics from the field of industrial organizational psychology that kind of is the spear of the tip of the spear, rather, in terms of how to actually put into effect policies and practices that actually are fair in practice in result, particularly around performance evaluation systems, around pay and promotion outcomes. This is a technical area. And again, the framing of it as DEIA is helpful, but what I'm describing predates this discussion by decades. And in fact, goes back to the start of the post-World War II era and the rise of the use of analytics or data analytics to assess the impact of policies and practices on the workforce, and in particular, relating to people who are disadvantaged or underrepresented. And so I think there, employers are wise to think in those terms, to be analytic, to be thoughtful about how to evaluate their systems and policies in a way that actually serves their own business purpose. As an illustration, if you have a system or policy that is fair in outcome, that's measured, that will help the company's bottom line. That is pro-employer. That helps people, employees, do their job better. They're properly resourced, they're given the same opportunities. There's a benefit to the employer. There's a dollars and cents benefit. In fact, I've said that so many times to companies and these kinds of discussions. And oftentimes they get it. They say, you know what? It's a fair point. We have a policy of practice or system in place that's disadvantaging people of color, providing less resources. And if we just improved those systems and treated people fairly in all respect, that will improve our bottom line. It's good for business. It's a good idea. And oftentimes that's the net consequence, that the things that we challenge are improved upon, advantages our clients, but also serves the business purpose of the enterprise. It's a win-win. I've said that so many times now in my career. And you know what? Sometimes the employer says after the fact, okay, we got it. That worked. And we didn't like that you sued us, but we're happy with the result.
Thank you. I want to invite anyone else to chime in if they're still with us about, sort of last words in terms of the importance of engaging in these efforts and standing strong in our commitment to the purposes of Title VII and addressing systemic discrimination in all its forms.
Well, thank you. And I would just say you probably said it pretty well already, and I appreciate for each of you, but really want to emphasize that as we think going forward about each of these issues that we intend at the EEOC to also be contributing to a conversation.
Thank you so much. Well, I'm going to wrap up our webinar here and just again thank all of our speakers and panelists today. We so appreciate your insight and expertise. We invite our attendees to, if they want to learn more about what's happening with these cases and get more resources, to visit our website at lawyerscommittee.org and to stay tuned. We will have more to come and more to say, and after these decisions come down, which are expected anytime now in the month of June. And just to close, that we are, wanting to remind the community at large that it's so important, it's imperative to continue these measures, and that together we can realize a multiracial democracy, and we must stand up against these challenges and continue these efforts. So again, on behalf of the Lawyers Committee, thank you all so much for joining today to learn more about these cases and what they could mean for the workplace. And we invite you to continue to engage with us as we continue in this fight. So thank you all so much, and this will conclude our webinar.